Okay, so let's start with segment 10. So segment 10, we're going to be talking about the heir dynamics and where it can be some conflict and how we get that to clarity. So one of the things in estate administration, of course, there can always be some conflict amongst the beneficiaries or the heirs. And it should be noted that here in our firm, we don't handle the contested cases, but it doesn't mean that there's not going to be issues that arise, especially when you have one of the children that's kind of quote unquote in charge, and there may have been some history of conflict amongst those beneficiaries prior to the parents passed away. So, that being said, in situations where we do have some conflict or we want to try to set the case up from the very beginning to avoid that conflict. And so, what can we do to make that happen? Well, one is, when you're looking at the case in the very get-go, you want to set the matter up for success for not only the personal representative, but the beneficiaries of the estate. So part of that would be to communicate the process, both to the personal representatives, but to the beneficiaries as a whole. You also want to set clear expectations, right, as to the timeline and what the legal requirements are. I mean, everybody wants to have this estate be done and over with as quickly as possible, but there are certain things that have to be done in a certain order. And so you have to methodically get through that process, such as notifying creditors, filing tax returns, paying taxes. So you want to make not only the personal representative, but the beneficiaries aware that we have to hit these legal requirements along the way. And so what we've been trying to do here within the firm is to create visuals, handouts, a timeline or a flow chart that gives a visual of that probate process and those notable timelines. That way they have something that they can refer to and they're aware, okay, there's going to be certain points along the line that we've got to hit. And so until that's done and those timetables have kind of been met, we're not going to be able to get to the point where we can close out the estate and distribute. So there are some timelines during the probate process. And so, it'd be great so that we could just describe what those timelines are without all of the legal jargon. So let's get some clarity around those timelines. Um, so when you look at kind of a 90-day roadmap to kind of keep the estate on track, the first thing is once you have the letters of administration that have been entered by the court. So the letters of administration is the document the court enters and the judge gives the authority to the person representative to act on behalf of the estate. So within that first 30 days of when the judge signed the letters of administration, we want to immediately then get certified copies of those letters. We want to get a tax identification number from the IRS for the estate. We want to have the person representative open the estate account. And then we're going to start an inventory of the assets, right? We're going to start asking for date of death values for different bank accounts, getting appraisals on the property. So we're starting to gather that information. And then we also want to publish a notice to creditors once a week for 2 consecutive weeks, which will start the 90-day creditor period. All right. So in that first 30 days, those are kind of the key elements that you want to make sure that are being done, again, to keep the estate on track. When we get to the 60 to 90 days, within 60 days of the letters of administration being entered, an inventory with the date of death value of all of the assets the decedent owned as of the date that they passed away that did not have a joint owner or beneficiary, not in a trust, those assets would be included on that inventory with the date of death values. And that would be filed by the court within 60 days of the letters being administered or being signed by the judge. Also during that time, now that we know what the assets are, making sure that those assets are safeguarded, right? We want to make sure that any ongoing bills associated with that, let's say, piece of real property are being paid, that insurance is current and in effect. Repairs are being made as needed. So I had a case one time where during the estate administration, the homestead, there was some kind of a leak within the property. So we wanted to get on that and get it repaired as quickly as possible. So there was no other damage to the property. And then you're also speaking with the financial advisor. Hey, are the assets invested properly? Are there any risky investments? And certainly talking with the accountant as well. Also, during that 60 to 90 days, you're notifying any creditors that you have now been made aware of or what could be creditors. What are going to be some red flags that can pop up in the estate where there could be some behaviors that instantly put an executor at risk of personal liability and kind of some guardrails around that. So we've been asked, previously, hey, what are some of the things that a personal representative might do that would put them at risk and some personal liability if they don't handle things correctly? So I would say one of the top behaviors is not managing or insuring the assets properly, right? So if you've got a piece of real estate, the challenge is making sure that you've got proper insurance on that property. And it can be a challenge because oftentimes with insurance companies, if the property is sitting vacant, they don't want to insure the property. So sometimes it can be difficult if there's not insurance already on it, is to try to secure insurance on a vacant piece of property. So that's first and foremost is making sure that you're safeguarding, managing, and insuring the assets properly during the estate administration. Also, another behavior that can expose the personal representative to liability is failing to properly notify creditors. Again, we just talked about previously that any kind of reasonably ascertainable creditors, you can't just rely on the publication in the paper. You've got to send them a notice to creditors directly. Um, and probably the third behavior that would expose the personal representative to personal liability is distributing all the assets before debts are handled properly, taxes are resolved. So when we get into that again, distributing assets early, you've got to make sure that you set aside enough assets to pay any valid and enforceable tax debts, and of course, any taxes that need to be resolved and paid. So, as far as one small process that you can implement to prevent these big mistakes, I would say within our office, one of the processes that we rely on is our case management software program has a workflow that we have created that will track any statutory deadlines so that we make sure that we're not letting things slip through the cracks and we can keep our personal representative on track to hit those key dates. Next segment, out of state beneficiaries or heirs and snowbird realities. Okay, so here in Florida, obviously, we are a state where we have a lot of retirees moving here from up north, and they come here to retire, and ultimately they pass away as a resident in the state of Florida. And so, oftentimes, all of their family still lives in those other states where they originated from, or of course, moved across the country. And so, when we have those heirs, or what we call beneficiaries of the estate, one of the things that we like to do to make sure that the paperwork that flow is efficient, and again, we're making sure that deadlines are being met, is really leveraging the technology that we have now. I mean, again, going back 27 years ago when I first started practicing, the issue would be that, you're having to mail things to those beneficiaries and waiting for them to sign it and then mailing them back or maybe a fax. But, technology has obviously changed significantly over those last 27 years. And we're able to use, if possible, if our heir or beneficiary is somewhat computer savvy, we can use DocuSign and, we can communicate with them via email and have them review documents. And when things need to be signed by beneficiaries, having them be able to sign a DocuSign document that we can then quickly file with the court. So I think the biggest thing in dealing with beneficiaries is number one, leveraging our technology, but also providing those clear timelines and being very proactive through the case about next steps. And In our office, also, what we've done is if the paralegals have reached out twice to whether it's the personal representative or the beneficiaries, then our next step is okay, that's communicated to the attorney, and then the attorney can reach out to ensure that we can impress upon them. Again, it's really important that timelines are being met. And if we're not meeting those timelines, then we can get dinged by the court, get those orders show cause, and that's going to further delay and complicate matters. So again, leveraging that technology, providing clear timelines, and being proactive throughout that case when you've got those out-of-state heirs, beneficiaries, so that we can keep the estate on track.